Perfect. Good, good, good. All right, so we're going live. Now, here's the basic thing that you need to know. We have some basic rules with the questions and answers method that we use for these videos. The rules are super duper simple. Now, remember, I just woke up. It is Saturday morning. I am super sleepy. I am super out of it, but that's okay. With that said, yesterday was a special, special day. I went to a restaurant last night after working all day, and basically yesterday was the 11th year mark day of the law firm being in existence. So I've owned the law firm for 11 years. It was a huge day, but I am super sleepy this morning. Now, with that said, the rules for this video, very straightforward, very straightforward. The rules for this video are no story mode when you call in, have a fake name ready to roll, have your legal question ready right up front, and basically you get 5 to 7 minutes. It's only like, surface level information because I don't know your full claim. And frankly, a lot of callers, they kind of withhold some facts that might make them look poor in a particular situation. So just be aware of that. Now, with that said, I'm going to be doing a total of 3 videos. The phone number to call is 407-279-1754. We'll go ahead and get you started. That way you are ready to go. I'm going to get this phone ready to go. Okay, so when you call the 407-279-1754 phone number, it's pretty darn simple and straightforward. You go ahead and get your 5 to 7 minute call in, only certain level of information because I don't know your full claim. And then, of course, have your legal question ready and use a fake name. Let's get into it right now. We're going to go ahead and open it up and begin the process. Charlton Zimmerman said, Walter, are you in India? No, I'm not. I'm just super duper tired, super tired. I am in Florida right now, post-hurricane. Super awesome, fun times there. Here we go with the first call. Let's get this rolling. Okay, let's see what we got. Hi, this is Attorney Walter Hnot. We are live on YouTube. What is your legal question? Go ahead.
Hey, Walter, just wondering real quick, is it a wise idea to try to use the trial work period, or are they just using that as a tool to get you off benefits?
So, and you're wise to ask that because that program has a lot of little requirements and little punishments that go along with it. So the reality is that if you feel like you can give it a good shot to actually try and work and, work with the managers that you're going to have at these companies that you're interacting with. Because remember, at the end of the day, you need the SSA person to be happy. You need yourself to be happy, and you need the managers that you're working with to be happy. And then if you truly can't do it, it usually helps if there's some significant medical change that allows you to say, I can no longer do this program, yada, yada, yada. Here's what happened, etc. So remember, you've got to keep those 3 groups of people happy. So the first thing you really want to ask yourself before doing the Ticket to Work program is, do I know individuals that I'm going to be working with? Are they going to be, pleasant, nice, helpful towards me, make sure that I have the accommodations I need to go ahead and complete the work? Or are these complete strangers? And these managers are just total strangers. They don't know me. I don't know them. One of those things. So, if they're complete strangers, it can be a little bit scary because you never know specifically what they're going to really request of you or how they're going to treat you when you're having a bad day or you don't show up on time. So in your situation, like, what are you looking at?
I haven't decided anything for sure. I'm trying to do some homework before I even think about it.
Sure.
I don't want to get myself into a implication here because I'm 61 years old already, and I don't want to lose benefits if I can't do it.
So what I would say is this. The main thing with this situation is your main focus is to do like a tester thing. See if you can do some sort of work, away from everything that normally is like, traditional work, but just do some, practice work for a traditional like 8 or 9 period hour for a couple of days. And you just stick with that. Okay. You just do that and, see if you can actually test yourself to complete the tasks. If you can't, then, pretty quickly the Ticket to Work program is going to end in failure with not being able to complete the program. If you can, you consistently can do it for 3 days, then there's hope for you to be able to go ahead and complete it at a traditional job. But remember, a lot of these jobs, it's like anything with life. When you start a program like that, you're starting at the bottom. You don't have a managerial position. You don't have, a higher level, situation. You're at like the bare bottom. So if, they're going to expect you to run around and complete things, they're going to expect you to be there all hours. They're going to expect you to do this, that, and etc. So just realize the jobs that you're going to be presented with are, the very entry beginning positions. So just remember, there's no preferential treatment,
Okay. All right.
Yeah.
I just wanted to check with you and make sure before I even dove in the water.
Yeah, sure, absolutely. But go ahead and check it out, try it out, do a test run, and then catch up with us, and we can always go from there.
All right, sounds great. Thank you, Mr. Walter.
Thank you, good sir. You have a wonderful, wonderful day.
You do the same now.
Thank you. Bye-bye. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yes, hi, Walter. This is Lisa.
Howdy, madam.
I was calling with the question of I'm on disability.
Mhm.
I was married for 10 years. My husband passed 2 years ago, and so I have filed for his Social Security.
Mhm.
I am in the adjudication stage.
Mhm.
It's been over 2 years, and I have not heard from them.
Okay, so just to summarize, you have disability benefits. You're looking to tap into your husband's, and basically you're in 2 years of adjudication. Are you in 2 years of adjudication for disability or for the spousal benefits, the widow's benefits?
For the widow's benefit.
Oh wow. Okay, gotcha. That's kind of super surprising. What is holding it up? Because usually, for the widow's benefits, that's you either are it or you're not it kind of gig. There's no like wiggle room or gray room on that thing. So what happened?
The last time I spoke with the agency, they just had me to fill out as basically what she told me. I was like, I had to be approved, and so I'm going through that stage of approving. But it's been 2 years, and I haven't heard from them in 2 years. They sent me a file of a large file of papers to fill out. I returned everything as if I was filing from the very beginning. I remember those paperwork, but I just haven't heard back from them.
Okay.
And I'm about next year. I will turn 62 next year, which I was planning to do the early retirement, and I didn't know how that would fold over, how that situation would fold over.
So, I mean, the big thing is this. So, keep in mind your SSDI benefit. You're on SSDI, not SSI, right?
Yes.
Okay. So the thing is this: when you go and hit 62, you're just going to stay on SSDI benefits, and you're going to walk those benefits all the way to 67. But what you're really asking me is, do I get additional money if I get my, husband's or ex-husband's, as a widow's benefits on top? So first question I have, if you've called the SSA and asked the SSA if they were to go ahead and give you a hybrid allowance with the SSDI benefits and the widow's benefits, would that increase your benefits?
Okay.
So you want to ask them that. And the reason why is some people, their SSDI amount is so high that if they receive widow's benefits, it wouldn't actually increase it. It wouldn't add on top of it. So, because remember, it's not a full stacking benefit. You don't get to like take one and then put the other one on top. It's an averaging benefit. So, you could have worked. I mean, did you work a lot more than he did throughout his life?
No, he worked more than I did.
He worked more than you did. Okay, so yeah, very likely then that his benefits should be added on top of yours, and you'll get a little bit extra on top. But do you mind if I ask, what is your monthly payment right now or benefit?
$1,100.
Okay, so $1,100. So, okay, so in that instance, very likely his benefits will be able to stack. Okay, so in that instance, this should be a simple, straightforward thing. And you were definitively married to him, like a traditional state-based marriage, right?
Yes.
Okay. It shouldn't take 2 years. This is one of those things where it takes a very short period of time. You've already been found disabled. We already know that he's terminal and has passed away. So at this point, this is something that should have taken at max 6 months. This claim fell through the cracks. So bottom line is, when was the last time that you talked to the SSA about it?
It was April of this year.
Okay, April this year. Okay, so bottom line is this. So what was the last thing that they told you when they were working on the claim?
That was the last time that they sent me a large stack of paperwork to fill out, and I filled those out and sent them back in. And she said, you will hear from me, and I'm still waiting. I haven't heard from them. So I didn't know, shall I make that call back again and ask them, hey, what's going on with the case?
So here's what I would do. I would call the SSA at the phone number on that paperwork and ask them, number one, is the claim with the local field office or is the claim with DDS? Again, is the claim with the local field office or is the claim with DDS? The next thing I would ask them when you call in, have they made a decision at this point and are waiting for a manager to process it? Have they made a decision at this point and are they waiting for a manager to process it? Next question, are there any holdups on the file? Are there any holdups on the file? You know, sometimes there's like little things that catch and then they hold the file up and they can't process forward. So you want to ask, are there any holdups on the file? Okay, and the final thing is that I need you to go get is you need to ask the rep on the phone, who is the person who's handling it and what is their extension number? Again, who is the person who's handling it and what is their extension number? Grab those details. And then basically you can always catch up with me during the live again, and we can go through kind of where you're currently at and what's going on with it.
Okay.
Perfect. Perfect.
Okay.
Excellent.
Well, I thank you so much for the information, and I will be getting on top of this Monday.
Absolutely. You have a wonderful, wonderful day. Yeah.
Thank you. You too.
Bye-bye. Thank you. Bye-bye. So we're going to go to Lexa R's comment real quick. My friend has a bad hip problem, arthritis. He lives off Social Security, which probably means retirement. He is 66 years old and lives alone. He wants to get help, but doesn't know how if he qualifies. So asking if he can get disability benefits. Can you please let me know? So I guess, all right, let me go through the comments real quick. Lexa, I'm not sure, but I think he receives more than 1,000. He stopped working close to 10 years ago. So if he's trying to get disability, he won't have enough quarters of coverage to apply right now. And keep in mind, if he's 66, he likely, if he's right now already 66, he probably will be found disabled. Or sorry, he will probably reach full retirement age at around 66 in some months, which means that once he reaches full retirement age, he can't get onto traditional disability. Because remember, SSDI benefits, you can get on that and ride that until you hit your full retirement age. So in this instance, he's probably not going to be able to go into disability benefits. He hasn't worked in 10 years, so he won't have enough quarters of coverage. He will for retirement, but not for SSDI benefits, because for SSDI benefits, you have to have 20 quarters of coverage within the past 10 years. If he hasn't worked for the past 10 years, then he doesn't have those 20 quarters of coverage. The other thing, too, is that he's probably reaching his full retirement age. So, you know, bottom line is once you reach full retirement age, you can't go on to regular disability benefits. So in this instance, I would say very likely he can't go on to disability benefits. So that's just a heads up with that situation. But a super thank you to Lexa R and Mark Vietti for the $20 donations. That's absolutely amazing, and I super duper appreciate it. And this is actually the day after the big day. This is the first day of beginning, basically, you know, year 12 of the law firm being in existence, because we just finished 11 years, which is just absolutely incredible. Let's take another call real quick and keep this thing rolling. Here we go. I'm going to call this person back who called a couple of times. Let's get him on the phone. Let's see what we can do. Let's see. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yes, Walter. I'm having some serious issues with the SSA regarding my disability claim, and I'm not quite sure how to handle it, but I have an upcoming disability hearing before an ALJ in November, and they are starting to lose vital paperwork related to my claim, because I already have a disability lawyer, but they've been losing letters from them that they've electronically submitted to them, like stating for witnesses to be subpoenaed for my hearing, in particular, certain medical providers that agreed to come to the hearing. I became aware recently that they had lost that letter for a month. It had to be sent to them again 2 times before they got it. Then they added it to like a stack of paperwork and didn't even send it off to the disability judge to be handled. And then they had to do it when I called them again. And I'm just at like a loss. I feel like they're trying to already play games and rig my hearing.
against me.
So the main thing is this: a lot of the disability judges don't actually read through the claim until the night before, and they do a quick review of the DDE report. So if you're expecting the disability judge to like do a bunch of reaching out to this group or that group, or seeking this or seeking third-party witnesses to be present, or third-party professionals to be present, it's likely not going to happen. They're super overloaded. They don't have enough of the judges, and they're just in crisis mode. So yeah, go ahead. Yeah.
My understanding is that from my disability lawyers that if they're sent a list of witnesses that I want subpoenaed to come to the hearing, that they have to issue those subpoenas. So are you saying that
they absolutely
don't?
They 100% are not required to. That is 100% false. No, they don't have to. They as an adjudicator have the right to go ahead and either take advisement on it or deny it as a request or approve it as a request. They are not required. I mean, think about that. That would be moronic if it was required. If they were required to have the President of the United States and the direct descendants of the KFC chicken franchise and some random person named Bob present and to subpoena them, if they were required to do that, that would never work. They have the right as adjudicators, the judges, to choose who they believe would be preferential towards the adjudication of the claim, whether for or against you. So there's no rule that require. I don't even know why anybody would say that. Are you sure this other person's an attorney?
Yes, it's coming from my disability lawyer's office.
That's never been a rule. There's never been a rule that says you can make a list of anyone you want and they have to go subpoena them.
I know they sent them the list of the witnesses we wanted subpoenaed.
I mean, that's fine.
I have 3 medical providers.
Yeah, that's fine, but that letter doesn't mean that they have to do it.
Okay, but wouldn't that be a denial of due process?
No, because you have an attorney. If you want somebody to be there, you have to basically go ahead and submit things to that person. And if that person is relevant to the claim, then the judge can go ahead and give, a decision on that. And if the judge does this hearing, remember, it's just a hearing. It's not a trial.
Mm-hmm.
If they do the hearing and they decide, hey, okay, this person will be relevant for more testimony, they can send out interrogatories. They can go ahead and request an additional hearing be completed, etc. Mm-hmm. But you can't just send them a magical list and say, de facto, you have to subpoena all these people or else you're in trouble. That's not how it works. It's never worked that way.
Okay.
It doesn't even work in other court systems that way. And this is a relaxed version of a court system because this is supposed to be a non-adversarial, like we're just trying to figure this out kind of hearing system. But no, it doesn't. I don't know why that attorney would ever say that. Either they don't practice this field of law that often, or they're older, and I don't know. I just, that's 100% incorrect. If you want people to be present, you have to go ahead and basically, if you want people to be present, you have to go ahead and send out a request to them. And if you want the judge to subpoena them, you can send a subpoena request, but that doesn't mean that the judge is going to subpoena them. The judge always has discretion on that as to whether or not they want to bring them in.
Okay, because I have 3 medical providers that want to come. I have a pain management doctor, which has been very interested in my case and why I keep getting denied. I have my psychiatrist and my therapist that I've seen for over 5 years that all want to come.
Well, are you paying them to come, or how is that working out?
I've offered to pay them, but they've volunteered at this point that they want to come regardless.
So then you don't need a subpoena. You can just notify the judge that you want them to be present to give testimony during the hearing.
Okay, so that's what we got to do then.
Yeah.
Okay, I know I meet with my disability lawyer on the 1st about this. Mm-hmm. Because I'm trying to figure all this out and why I feel like the SSA has played games on this.
So, well, I mean, you definitely got some wrong information from the attorney. So the first thing you need to know is this. The judges usually will look at the actual file the night before. They'll read the DDE document from DDS as to like a quick summary as to what's going on with the claim. Then if they see any requests in there, they'll let you know during the hearing that they're going to approve or deny them. But, that's at the hearing kind of gig. Now, normally when you have like a regular traditional, hearing setting that leads to a trial or whatever, The hearing is for the purpose of specific rulings. So like it'll be like, okay, we're going to rule on these things if they pop up, or these are the categories of items that we have to rule on. So in this case, like, it's just, it's not going to be, I don't think you understand that this is like a non-traditional hearing compared to like a civil or criminal trial, right?
I didn't really understand that because I know I had a hearing before a disability judge a couple of years ago, and he wasn't really the best judge. He's developed a really bad reputation since, but I'm just trying to make sure that I have fair due process.
Yeah, sure. Yeah, no. So, if they are willing to come, all right. So, and this is, I got to be honest with you, this is not how this should be done. The way you should have done this is have basically RFC letters and an accompanying letter completed by basically each of these physicians, and then submit those as, basically testimony on behalf of the medical expert to the SSA. And they even won't even be considered a medical expert unless the SSA blesses them as such. But the bottom line is that that'll go in as medical evidence. And then from that, yeah, go ahead.
You're talking about residual functional capacity reports, right?
Yeah, so you got to have an RFC letter completed, and then also a letter from them specifying why they believe you're disabled. That's like if they're really willing. Yeah. So if they've already submitted that, yeah, then there's really no purpose to have them present for the hearing, because if it's a good RFC letter, it outlines significantly every single detail that you're required in order to show that you meet the statute requirements. So, having 3 people present for the hearing, I can tell you right off the bat, the judge is going to go ahead and just say no, because the judge only has 45 minutes for the hearing. So, that's the first thing. The second thing is, like, if you already have the RFC documents completed and a letter from the doctors with, specifics on why they believe you wouldn't be able to work, then there's no purpose for them to be there, because they've already put down on record exactly what their statement is going to be. So
I know that when those RFC documents and letters were submitted, when I was going through reconsideration, the adjudicator said that they considered it opinions from those doctors.
Yeah, they're always medical opinions. Yeah, you bring them to the hearing, it's still a medical opinion. It's never definitive. The only thing, so all forms of medicine are truly a form of an opinion. The least form of an opinion that they have is when the machine outputs the information. So basically, the machine will go ahead and say, okay, here's my output. That they view as like the ultimate form of medical evidence, because there's no human potential bias. But it's always opinion. There's never a situation where it's not opinion.
Okay, because I'm just wanting my best case presented, because like I have 15 medical conditions. They've drugged me through the gutter on this for 5 years, and I'm just really concerned that they're just trying to arbitrarily deny me as much as they can. When I spoke with my congressman's office recently, they said they have it built into the mathematics that they hope people like me just go away and die.
Yeah, of course. That's why they have 2 initials at DDS, and then you go to a hearing where there's an actual adjudicator that knows the system. So, but remember, so the number one thing, if you already have each one of those doctors with an RFC letter and a letter stating why they believe you're disabled then your main thing is you have to work on you, the person who basically is the weakest link in the chain with your testimony, because your ability to answer the questions is where I've had brilliant claims. I've had amazing claims. I've had claims where the homeless person de facto, no matter what you did, was super disabled. There was no way around it. It just is what it is. I've had perfect claims, and the claimant got on the hearing and destroyed the claim. So the biggest thing you've got to work on now is making sure your testimony is good to go.
Okay, and I can definitely work on that with my lawyer.
Yep, perfect.
But I'm just really concerned, because it just seems to me that they're just trying to deny due process as much as possible.
No, they get to rule on those basically, at the hearing and give summary. But if they've already got RFC letters in, that's good to go. But remember, one of the things you have to be careful with, which again makes me call into question this other attorney that you have, heavily call into question the other attorney, is that you have to make sure that you don't piss off the judge and make the judge really hate you as a claimant before the claim. Because a lot of this is getting a human being sitting across from you, who's also a lawyer, who's in the form of administrative law judge, to approve you.
Mhm.
And if you bring 3 medical professionals in, right, and say they're waiting on the phone, and then the judge has to do a 2-hour long hearing, you are going to piss that judge off.
Wow, I didn't realize that having due process would piss off the judge.
See, you're coming at this from the wrong perspective. You're coming at it from the I deserve this, and you don't know the actual, policy, the POMs, the HALEX, how the whole thing is going to, actually be applied. So you're coming at it from like a very broad approach of like, well, I demand this. Here's the thing. This is not in a simple game of they have to give you what they want to give you. Okay. This is a game where even where you might be disabled, they can still deny you. So you have to realize that you have to play the game to get the judge to believe that you were disabled, like you as a claimant, and then basically give an approval. So there's a lot of trial tactics and strategy beyond just like the cutesy I must receive due process. There's a lot of stuff beyond that you have to consider. So I would supremely advise that you go talk to that attorney and start to work on trial tactics, because your testimony, what you're going to do to make sure the judge likes you, the story that you're going to tell about how you're limited now, and the emotional connection you can create with the judge with that, these are all relevant to your situation. But running into that hearing and saying, Your Honor, I demand due process, is basically an FU to the judge, and that's not going to get you very far.
Exactly, and I'm not looking to upset to tick off the judge or anything, or upset him anyway. I'm trying to make sure that my legal rights are preserved.
Sure, yeah, and that's fine. There's a lot of ways to do that, but just go get your attorney to start working on that, start pushing that, because I'm telling you, like, if you've already got the RFCs in there, you should be working on testimony. You should be working on structuring how you're going to approach certain topics, when you're going to release information, and what your actual delivering, of the information is going to look like. Because, if I ran hearing questions with you in a very short period of time, I could get you to say something that would hurt the claim. And so you've got to make sure that you iron that out. That way you don't fall into that trap. Yeah.
Okay. All right.
Perfect.
Thank you so much.
Absolutely. You have a wonderful, wonderful day, okay?
You too.
Thank you. Bye-bye. Bye-bye. Perfect. So, we got a bunch of questions in here. Let's see. Dana Barley, what if you were denied wrongly and reapply years later? Would they look at the old filings to check for errors, or is it just from the new filing date? They only look at the new filing date going forward. If it's truly bad that they screwed something up, you shouldn't have waited that many years. A. B. If there's like fraud that the SSA committed, then you can always use that to go back in time. That does exist, but only if you can prove that there was some sort of fraud occurring. And you usually have to use OIG, Office of Inspector General, which are like the SSA's attorneys, to actually figure that one out. Let me see what else we got in here for questions. Hi, I'm 51 and disabled according to doctors. Everybody's telling me I have earned SS, and I've been working on it since November 2021 and have been getting runaround. So Brian, here's the thing. There's a lot of runaround issues that are going on right now with the SSA. Number one is that they don't have enough employees to actually process the claims. They're in a state of crisis, and the federal government is not funding them enough to actually go and do what they need to do as an agency. Number two is that the amount of trained individuals is very low, because a lot of people get hired and then they quit, and then they get hired and then they quit. So you don't have really, really trained individuals that actually know what they're doing at the SSA. So you're getting the runaround. It's because a lot of people at the SSA are running around themselves because they don't know what to do. The next thing, too, is that there is a bias at the SSA, of course, against individuals. And, just to kind of clarify, imagine you're a judge and you're sitting there and you have 5 hearings in a single day. And that, this hearing is a wounded veteran, and this hearing is a quadriplegic, and this hearing is a person with fibromyalgia, and this hearing is a person with anxiety, and this hearing is a person with a degenerative disc disease issue. Which ones should the judge approve? The judge has a very low percentage approval rating, then they're only going to approve one. If they have a mid-low, right, a mid-low one, then they're going to approve 2. If they have a medium one, they're going to approve 3 in that day. So are you either with a judge that's going to approve 1, 2, or 3 out of the 5 of that day? And remember, the first 2 that are probably going to go through are the wounded veteran, that's having difficulty and has 100% PNT. And then the other one is the quadriplegic. They'll actually be the first one to go through. And then the next one is, it depends on what the judge is going to go with, what severity they are, things like that. All right. Let me go to the next caller real quick. Here we go. Oh, let me get this going. Here we go. Perfect. We're on speakerphone. Let's get this person on the phone. And we're going to do this as the last call, and then we're going to go to the next video.
Hello.
Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
I've been on disability for about 7-8 years now.
Mm-hmm.
And my question is, I've developed more serious conditions than I had before when I filed and got approved.
Mm-hmm.
Do I need to report those conditions to the Social Security, or do they pick up on that in some other way?
So when they do a CDR, they're going to go ahead and basically look at essentially what your conditions are. So, just keeping all that in mind, for example, they'll buy medical records from your doctors using an 827 HIPAA. They'll go ahead and basically, see what all the new diagnostic impressions are. So they will, when they do their review, go ahead and pull those up. However, if you want to be ahead of the ball, you'll, get the records and submit it when you're getting close to basically a CDR date. But they will purchase those records either way and kind of go through that process. So they will get it. It just depends on, essentially whether or not you want to be proactive or whether or not, you want them to just handle it.
I've only had one CDR. Is that typical?
One CDR is, it depends on when you're found disabled and, basically how old you are. So like, what is your current age?
55.
Yeah. So basically, if you are 55, then you're probably going to get another, I would say 3 or 4 CDRs, depending on how severe you are. If you're really, really severe, you might get one more. If you're not, if you're completely bedbound, you won't get any more. If you are, kind of just medium to severe, kind of moderate to severe, you'll get a bunch more. So bottom line is it all just kind of comes down to and depends on essentially, how severe you are and, how close you are to reaching that full retirement age where they'll switch you off of SSDI benefits onto retirement benefits.
Okay. All right. Well, thank you for calling.
Absolutely. You have a wonderful, wonderful day.
All right. You too. Thank you. Bye-bye.
Thank you. Bye-bye. Okay, perfect. So with that said, everybody, we are going to go to the next video. I'm not even sure which one is set up as the next video. Let me check it out real quick. Hold on. And then we should be good to go. Now, remember, I didn't go live on Thursday. I went live basically today because I didn't have a lot of power and phone service on Thursday because the hurricane hit Florida. If I did help you during this video, please remember to like and subscribe. And then the big thing that helps me out is head over to Google and type in Disability Resolution Law Firm or Disability Resolution Florida and go ahead and leave a review there. Like throw some stars up there. I love waking up to the 5-star reviews. That's like a big benefit thing of doing this stuff. Now, with that said, I do go live traditionally on Mondays and Thursdays. And then I have a little private hour option too, where you can buy basically, a private hour if you have a more complex question for me, because this whole setting for these free little questions and answers is more like a 5 to 7 minute back and forth kind of gig. But if you need a full hour, which some of you do, like a lot of you have a hearing coming up and you haven't been able to run questions for the hearing, or you're trying to transition out of work into the disability field and you're wondering how you should structure it, or you have a CDI unit that's on your butt trying to basically figure out what's going to happen to you, what criminal charges are going to be filed, stuff like that. So all right, now the next video that we're going to be doing, I'm just checking out right now, are the major changes to Social Security in October, and there are some whoppers coming out in October. So we're going to be going through all of those. Give me about 5 to 10 minutes to go ahead and get that video set up, and I will see you there. Attorney Walter Hnot, Disability Resolution PA, the most of you can subscribe to Disability Attorney in America. I'll see you at the next video in about 5 to 10 minutes, and I will put the link for it in the chat section right over here. I'll catch you a little bit later. You have a wonderful day and a wonderful weekend, and I'll see you at the next video soon. Thanks so much. All right. Bye-bye, everybody. Bye-bye.